The code was published in the Official Gazette after its passage in Parliament. It has been hailed as a major economic measure, aimed at aligning insolvency laws with international standards. Parliament's previous attempts to ensure recovery of public debt, through the Recovery of Debts Due to Banks or Financial Institutions Act, 1993, hereafter, RDBFI Act, Securitization, by the Securitization and Reconstruction and Enforcement of Security Interests Act, 2002 hereafter, SARFESI, deal with certain facets of corporate insolvency. These did not result in the desired consequences. The aim of the code is to a. Promote entrepreneurship and availability of credit, b. Ensure the balanced interests of all stakeholders, and c. Promote time-bound resolution of insolvency in case of corporate persons, partnership firms and individuals. The Insolvency and Bankruptcy Code 2016, IBC, enacted to address the troubling shortcomings in existing staggered insolvency laws in India and to bring them under one umbrella, is set up to face a monumental challenge and equally monumental expectations. At present, according to the data available with the World Bank in 2016, insolvency resolution in India takes around 4.3 years on average, compared with United Kingdom, 1 year, USA, 1.5 years, and South Africa, 2 years. India was ranked 135th, 190 countries in the World Bank Ease of Doing Business Index 2015 on the ease of resolving insolvency. Thus it is apparent that the code is perhaps one of the most critical legislations introduced in the recent years impacting the ease of doing business in India. The Insolvency and Bankruptcy Code 2016, enacted to radically change the process of insolvency resolution in India, is keenly watched by economists and jurists as well as businessmen and investors, for the reason that each aspect of the implementation of law has the potential to critically impact the ease of doing business in India. For this reason, the code is especially sensitive to interpretation, and it is vital that the issues thrown up in its inaugural year of implementation be recognized and the judicial remark on the same be understood. The present article thus traces the emerging jurisprudence of the code through judgments of the Supreme Court of India and the National Company Law Appellate Tribunal. It is a comprehensive code enacted, as the preamble states, to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximization of value of assets of such persons, to promote entrepreneurship, availability of credit and balance the interests of all the stakeholders, including alteration in the order of priority of payment of government dues, and to establish an Insolvency and Bankruptcy Board of India, and for matters connected therewith or incidental thereto. Legal framework of Indian insolvency and bankruptcy resolution procedures. There are several laws which regulate insolvency resolution for companies in India. These include I. Sikh Industrial Companies Act, 1985, E. Recovery of Debt Due to Banks and Financial Institutions Act, 1993, DRT Act, E. Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002, SARFESI, and Companies Act, 2013. These laws provide for the restructuring of debt, seizure and sale of the debtor's assets for repayment of outstanding loans. Similar laws such as the Presidency Towns Insolvency Act, 1909 and the Provincial Insolvency Act, 1920 regulate insolvency resolution for individuals. While these laws specify processes for resolving insolvency, a creditor may also approach civil courts for recovery of debt. The court seeks to consolidate the existing framework by repealing the Presidency Towns Insolvency Act, 1909 and the Provincial Insolvency Act, 1920. In addition, it amends 11 laws including Companies Act, 2013, DRT Act, 1993 and SARFESI Act, 2002.